Hey everyone, Judicial Watch President Tom Fitton here with our weekly update. Getting off to a rough start there. Thanks for joining us this week. So much to talk about. We had some Supreme Court decisions coming down. I think we're sharing with you at least a little bit about them. Big fights in Florida, pressuring Judge Cannon, who's treating Trump fairly. The left is going crazy after her. We filed a major brief in the effort to hide videos, or excuse me, the audios of Joe Biden's interviews with the special counsel. New videos have emerged, and of course the Biden White House is going crazy, suggesting that Joe Biden isn't fit for office. Plus, a startling new development in the Biden dog scandal. And of course, Judicial Watch never stops the heavy lifting, filing new lawsuits to uncover the woke virus at West Point, plus information about an ATF raid that ended up killing a man in Arkansas, the former top official or senior official at the Clinton airport down in Little Rock. So a lot to go through. First up, though, is what I think to be the constitutional national security crisis of President Biden's fitness for office. And a series of events and interviews videos have emerged documenting Joe Biden's cognitive challenges. I don't know how else to describe it. And what's happening in response to that is the Biden White House and their partisan left-wing allies in the media are telling us not to believe our eyes. And one of the more disturbing indications of this problem that Biden has occurred at a major fundraiser he participated in with President Obama out in Los Angeles. They raised, I think, $30 million. So it was a big fundraiser for them. Jimmy Kimmel interviewed them. And Biden had a freeze-up on the stage. And I talk about it in this video I posted to Instagram the other day.
Well, here we are, another Biden moment. Freezes. Obama, they're at a fundraiser in Los Angeles, by the way. Obama grabs his arm, escorts him off the stage, pushes him off the stage, really, right? Further disturbing evidence of Biden's cognitive decline raises questions about his fitness for office, let alone running for election. I'm worried, he's not fit to serve another day. Watch it again. There you go. Freezing. Obama grabs his arm. What must our friends think? What must our enemies think? America's weakened state as a result of Biden's cognitive issues. Share your thoughts below.
And they're telling us we should just ignore that. And Obama was just impatient. I don't know about you, but the idea that someone in that situation would freeze as he listens to the audience applaud as if he's not the subject of the applause. And those of you who are men, have you ever grabbed another man by the forearm to get him to come with you? You might do that for a disabled friend or disabled relative. And so there are two ways of interpreting what Obama did there. One way is that he was just announcing to the world that Biden's not fit, and he purposely was treating him like that. Or he just recognized someone having a disability situation, to put it charitably, and he went to help him. No matter how you slice it, it's not good for President Biden. And so this is fed into public concern about his cognitive difficulties. And the White House is now just telling us to believe them rather than our lying eyes. And I I sat and watched for Instagram the other day, the White House spokesman try to explain the way what everyone sees as reality.
American voters who are telling pollsters repeatedly for years now that they have serious concerns about this president's cognitive fitness are being misled by cheap fake videos? Is that
I'm
what you're
saying
telling
that
us?
there have been, in recent weeks, there have been cheap fake videos that have been fact-checked. They've been fact-checked by conservative media as well, to say that these videos are false. They're purposefully being altered.
So he's
That
fine.
is,
So he's
that
fine.
is, look,
He's fine.
the president has done more in his 3.5 years as president than most modern day president. I think that tells you everything that you need to do by looking at his record. And what you're seeing right now is Republicans, instead of talking what I just listed about, what I just talked about, they're really diving into these cheap fake videos. And it's in bad faith. That's what I'm saying. What they're doing is pure bad faith, and it's been fact.
The only cheap fake videos I see are the videos that news media are putting out of White House press conferences. What videos have been fact-checked in a way that's credible? I mean, there's that video, I don't know, I don't think we can pull it up so quickly, but that video of him with the G7 leaders, and there's a parachute team landing, and everyone's looking one way. He goes off and starts talking supposedly to someone else completely away from the group, out of it. And one of the leaders, I think it was the Italian prime minister, basically had to go grab him and bring him back. And they're saying, well, he was, you know, he was right to be distracted. It was perfectly normal. No one looking at that, or few people looking at it, who are being, you know, other than dishonest partisans and employees of Joe Biden, see it as anything other than, you know, an old guy with failing memory and cognitive difficulties wandering off. And I tell you, if it were a Republican president, a conservative president, President Trump, I mean, Ronald Reagan they wanted to remove for supposed cognitive issues almost immediately upon his coming into office. And this is what I would be doing. And I've been trying to educate people on this, because to me this is a government corruption issue. Because if government officials are lying about the mental health, the mental status of the President of the United States, that's a government corruption issue. And if it were a Republican president, this is what would happen. You would have a media firestorm of pressure directed at the vice president and the cabinet to exercise their prerogatives under the 25th Amendment. You would have multiple hearings in Congress exploring the 25th Amendment as it relates to the president's cognitive difficulties. And it would just be a political firestorm. Whether it would result in the removal of the president under the 25th Amendment, I don't know if that would necessarily happen even with a Republican. But what I think ought to happen is members of his cabinet and the Vice President, Kamala Harris, should be asked questions about President Biden's cognitive challenges. Has he taken a cognitive exam? They're widely available, easy to administer. Doctors can do it. And his doctor, who's a buddy of Biden, has refused to give him such an exam. He's over 80 and he hasn't had a cognitive exam? Why not? If I were the vice president, if I were in the cabinet, I'd be saying, Mr. President, we've got concerns by the American people about your state. So we want you to reassure us reassure us, because we've got this responsibility under the Constitution to take steps if there are issues. So reassure us, take a cognitive exam. Or what other exam would be required because it may not be necessarily dementia. It could be Parkinson's. I don't know. I'm not a doctor. But we're human beings. We've been around people, many Americans have, seen family members, friends, and such, who lose their cognitive abilities as they've gotten older. And I think it's a national security issue, and I think it's a governance issue. It's a constitutional issue. And what happens under the 25th Amendment? This is the way it currently works. So under the 25th Amendment, if there's a cognitive issue, if there's a disability that prevents the president from exercising and fulfilling his duties, one way, there are several ways, but the one way is, assuming President Biden doesn't want to do it voluntarily, basically say, I am disabled, the vice president and the majority of the cabinet can find him to be disabled. He's taken out of office for a period of time. The findings sent to Congress, and if Biden wants to battle it, I think he's put back into office under the 25th Amendment, and then it's up to Congress by votes of 2/3 in both bodies to decide whether he's able to serve. So that's the process. So there are a lot of checks in place. It doesn't necessarily mean that there will never be abuse, but to ensure that it's going to be more difficult to abuse that process, where someone just wants to engage in a political coup against the president using this disability issue. It's hard to get it done over the objections of a president unless there's strong support in Congress from both parties. It's necessarily bipartisan, the concerns would have to be. And that's the process. And that's what we should be talking about. This isn't a question of who you should vote for. This is a question of whether the president right now is capable of serving. And I think it's an open question. If I concluded that he can't serve, I don't know. I think we need more information from disinterested parties, physicians and others. You know, are people around Biden going to say the emperor has no clothes? No, not without political pressure and accountability. And I think that should be brought to bear. So all this effort to protect Biden, compare and contrast with the crazed effort to destroy Trump, and judges who are trying to do the right thing by Trump while protecting judges who seem to be breaking all the rules related to Trump. Did you see the news today or this week? There was a report that a lawyer buttonholed Judge Engoron. Engoron is the Democratic Party judge who abused Trump so terribly in this fraud case, this civil fraud case brought by the anti-Trump politician, Democratic Party politician Letitia James, and found he committed fraud somehow by not valuing properties as he was supposed to, according to Judge Engoron, the real estate expert. No one was harmed, no one was damaged. So he found he committed fraud and then fined him nearly $500 million. So he's trying to destroy his business. Well, this lawyer buttonholed Engoron and says that he and Engoron had, let me go to the tweet. I describe what he said. There's strong evidence of yet another incredible example of misconduct by New York Democrat anti-Trump judges. Judge Engoron evidently had an intense conversation about his abusive taste to destroy Trump's business with an outside lawyer. The New York State Commission on Judicial Conduct will now consider whether the rules of judicial conduct were violated in this instance, according to sources familiar with the matter. And the lawyer evidently talked to local news station NBC, the local New York station, to describing this conversation. And as I read it, he wasn't an anti-Trump lawyer. I think he was critical of Engoron. But Engoron engaged with him. And you're not supposed to talk about cases like that with parties in a private way, or certainly with non-parties in a private way. Completely inappropriate. And Judge Cannon, of course, is being viciously attacked. Judge Cannon is the judge handling the sham case that the Biden gang is bringing against Trump over the documents. The New York Times had some leaks this week saying that the chief judge in the district that Judge Cannon works in and some other judge, so that you had leaks by judges, supposedly told Cannon that, she should get off the Trump case. So what was going on? Were the judges trying to rig the case by knocking her off because she was seen as too friendly, or as I say, too fair? I mean, they're trying to blow up the justice system in South Florida to go after Trump because Judge Cannon is holding Jack Smith accountable. I mean, just today she had a hearing. Finally, there's a judge who's willing to take this issue on. Talk about the emperor has no clothes, over the issue of whether Jack Smith is constitutionally valid in terms of his appointment, and whether his powers are valid or not. And I've been long calling on the rule of law to apply to the Justice Department in terms of these special counsels. They go in and they hire these contract lawyers. I don't care how well established they are. They're contract lawyers, not subject to confirmation. I've been talking about this for years, and I have a tweet from almost, I think it's 6 years ago, talking about it with Mueller. Let's go to that. The U.S. attorney is appointed by the president, confirmed by the Senate before he can take up his job. And if there are prosecutors in the Justice Department who aren't subject to confirmation, they answer to people who are, or answer to people who answer to people who are. So there's this lawful delegation of authority. In this case, that doesn't happen. He is not supervised day to day by the appropriate officials in the Justice Department. Therefore, he doesn't really have the authority under our Constitution to do the work he's supposedly wanting to do, which is to investigate, and let's assuming he's doing the right thing and just trying to do his job. It's not about Mueller at this point. It's about the Office of Special Counsel. And if I were them, I'd go back to square one, however politically uncomfortable it is, to make sure that that office is lawful and lawfully run. The U.S. Attorney. So let's go back to that video, because I want to repeat the tweet. Let's go back to that tweet again. So, and I kind of retweeted my post. Special counsel operation is unconstitutional. And this was a quote from a brief filed on behalf of the former Attorney Generals Mukasey and Meese. Smith is the classic emperor with no clothes. Huh, I forgot I mentioned that, or that was in the brief. He has no more authority to represent the United States in this court or in the underlying prosecution than Patrick, I can't see, Mahomes, Kim Kardashian, or Mick Jagger, or anyone else like that. And the court should grant the stay. And so Judge Cannon was describing it, and as I was saying 6 years ago, I looked a lot younger then. It's disturbing how much younger I looked. Judge Cannon has the opportunity to uphold the rule of law here. This is a serious constitutional concern. The Supreme Court's been asking about it. No one's kind of raised it up there in a direct way yet. At least Trump hasn't. And, as I was saying 6 years ago, you have basically this rogue prosecutor who doesn't really report to anyone in the traditional sense. So what authority is he exercising? I mean, the only special counsel that could probably be appointed is someone who's been confirmed by the Senate, or someone who's literally supervised by someone who's appointed by the Senate, meaning like a junior prosecutor, because they don't have authority apart from the authority that flows from the president or confirmed appointees. I mean, that's the argument. And there's other arguments more technical about whether there's any spending authority for the position, which is a different issue. I mean, Thomas Massey asked Garland about this the other day. I think I played it last week, or we played it last week on, I don't know if we can find it. But Judge Cannon had a big hearing about it, and it went on for a few hours. I don't know how she's ultimately going to rule. I mean, the thing about the emperor with no clothes is, if you go back to the story, the problem with saying the emperor has no clothes in Washington, D.C., and it mimics this history of the story, no one cares. I mean, the emperor didn't care. He just kept on walking, quite happy, even though everyone kind of realized he had no clothes, but everyone didn't want to say anything. And even when they did, the emperor thought, just shows that they don't know anything. So that's the challenge of these types of challenges to the authority of an office that's kind of been used improperly for 20, 25 years now. Like Weiss, who is the special counsel for Biden, or Hunter, or whatever. No, it's for Hunter. Joe's protected, excuse me. He's a special, he was appointed as a U.S. attorney. Her, who was special counsel on the Biden document probe, was not appointed as a special, he was a former U.S. attorney, but he resigned, or, he left office. So I don't think he had proper authority under the Constitution to do these investigations either. At least that's my view. Whether the courts agree or not, I don't know. And in the meantime, we have this presidential debate coming up next week. And not only do you have rogue prosecutors, you have rogue judges. He's still suffering under this gag order. He's still facing the prospect of going to jail under this kangaroo court proceeding. And I don't know what the Supreme Court hasn't yet ruled on this, a big immunity issue, which I'm sure you've been following, about whether he can be prosecuted for acts as president after he leaves the presidency. I tell you, the new rules seem to me to be, if that's the case, that he can be, Biden can be prosecuted for enabling the invasion, for his new scheme to grant amnesty to 500,000 people plus, illegal aliens, for aiding and abetting human trafficking and child trafficking. So I don't know what the Supreme Court's going to do, but maybe Biden should be hoping the Supreme Court shoots down his efforts to prosecute Trump, because it will protect him. But the Supreme Court should also take action to curtail this abuse of Trump up in New York. And I talked about that, and the court can't do it soon enough. He's going to go into this debate under a gag order next week. That's incredible. I was on with John Solomon and Amanda, his co-host, just the other day talking about these issues. Let's play that.
Yeah, and I think the perception of much of America is that political retribution is continuing, especially in the case of this New York trial. And I don't think we've had you on since that guilty verdict. At which point the sentencing occurs, I imagine President Trump and his legal team are going to appeal. Do you think they should take it straight to the Supreme Court?
Oh, I think they should have taken it to the Supreme Court yesterday. I don't think they should wait for July 11th. I mean, it's abuse on top of abuse. I mean, we're facing the prospect of President Biden being held hostage to Judge Merchan and the campaign being held hostage. It's bad enough it's happening now during the campaign, but literally during a debate with Biden, he's going to be attacked on this. He's being attacked right now. And under this gag order, he can't fully defend himself. And on top of the whole involvement, or I would say the effort by New York Democrat politicians and a Biden donor, Judge Merchant, to hijack our federal campaign through this meritless prosecution and the sham verdict, it needs to be stopped by the federal courts. And the Supreme Court is uniquely positioned, given its unique authority in the federal system, to uphold the rule of law. You know, if the state of Arizona does something in the area of immigration law, the Justice Department comes down on them like a ton of bricks. Oh, no, we own the area of immigration. You can't do anything. You're preempted. But you have a Democrat court up in New York use federal election law to hijack and disrupt our campaign by pretending they can prosecute crimes related to it, and the Biden Justice Department is silent. They should have come in and shut it down. And if the Justice Department won't do its job, maybe the Supreme Court will. And I don't think the country should have to wait to see Trump further abused and our system further compromised through another kangaroo court proceeding, which is now being called a sentencing, which to me is as a political a proceeding as anything you'd see in places like Russia or China or North Korea.
Tom, earlier today there were reports.
Yeah, I don't know what the Supreme Court's going to do, but I think they should be asked to do something. I mean, there were decisions this week I wasn't all that thrilled with. There was a decision that essentially, I read it, it was a kind of a tax case, and I don't profess to be an expert in tax law or even taxes, but I didn't like it. As I was reading, I said, I don't like this, because it suggested to me that the court was willing to consider taxes on unrealized wealth or income. And the 5-4 majority pretended they were not necessarily opening up the door there, but many thought they might be. And this is a big issue, whether or not, because the left wants to essentially target unrealized gains in the property that people have, whether it be stocks or real estate. Imagine having to pay taxes on the increased value of your home or on the increased value of your stock portfolio, even though it's just sitting there and you haven't cashed it out. I mean, the left desperately wants to do that at the federal level. And the Supreme Court kind of opened the door a little bit to that. And then secondly, they ruled 8-1 on this issue about whether someone subject to a protective order can lose their Second Amendment gun rights, their civil rights. And the court said, sure, it's perfectly in line with the tradition of America. And I wasn't convinced of that. And the only person who dissented was Justice Thomas. And I quoted a story or an analysis of his decision. Let's go to that tweet. Justice Thomas was the sole dissenter with the powerful argument, and this is the quote from the SCOTUS blog, which covers the court. Justice Thomas concluded it is not about whether states can disarm people who threaten others, because states already have a way to do so by charging the person making the threat with an aggravated assault. The real question, he suggested, is whether the government can strip the Second Amendment rights of anyone subject to a protective order, even if he's never been accused of or convicted of a crime. It cannot, he asserted. So in my view, that's kind of like, as far in terms of being right, that's a majority of 1 by Justice Thomas. So I don't know what's going to happen with these other decisions, but it just shows you that even in a court that nominally 6-3 is conservative, you can get decisions that conservatives can disagree with often. I mean, in this case, it was an 8-1 ruling. I'm not buying into it. But the Supreme Court needs to take action to protect Trump. That's for sure, because they have an obligation, in my view, under our system of government to ensure the Constitution isn't blown up by out-of-control, politicized prosecutors and judges. The state of New York isn't going to fix it and curtail the abuses, then it's up to the federal government. Frankly, the state of New York shouldn't have been even allowed to mess in this area, as I talked about with John Solomon. So this is going to continue to be a major issue. The gag order will continue to apply to Trump, and he'll be the first president in American history, or former president, or candidate in American history to have to go into a presidential debate with a gag order. Unbelievable. You know, when I talked earlier about the issue of Joe Biden's cognitive issues, and you may recall Special Counsel Hur said, I'm not prosecuting Joe because jurors are going to think he's a nice guy with a poor memory and I won't win. Isn't that convenient? And he said, I based that not only on the transcript of my interviews, but obviously the audio. So we wanted, obviously, the transcript and the audio, and we were the first to sue for them. So we're the first to sue and the lead plaintiff in a lawsuit to get the audio. And since then, the Biden gang has said, oh, no, you can't have the audio. It will violate his privacy, executive privilege, and such. And A.G. Garland, the Attorney General, is going as in contempt of Congress to hide this video from Congress. That's how desperate they are to keep the, I keep on saying video, the audio. So we're in court, and we filed a major brief just today. Heritage Foundation filed a lawsuit after us. CNN and media organizations also agree with Judicial Watch, so we're standing with CNN in this case and all the big media. Judicial Watch asked court to order the release of the audio of Biden's interview with Special Counsel Hur. In our brief, we called some of their arguments repugnant. Repugnant. It's a terribly political effort the Biden administration's engaged in to destroy FOIA in order to protect Joe Biden from having this audio released and the consequences of that. They don't want the public to know what the Justice Department and Joe Biden's up to when it comes to this document prosecution or non-prosecution. Judicial Watch filed the first FOIA lawsuit and is the lead plaintiff asking that the Biden audio recordings of his interviews in Special Counsel Hur's criminal investigation of Biden's theft and disclosure of classified records. Now, the lawsuit already helped force the release of a redacted transcript of the Biden interview. The Biden Justice Department, in seeking to keep the audio recording secret, asked the court to ignore precedent and rewrite FOIA law. The Biden agency demands that a law enforcement executive privilege exemption be rewritten to help Joe Biden, wants to change FOIA law to protect, after 50 years of being politician, Joe Biden's privacy and his voice, and seeks to potentially end FOIA with a new argument that the possible AI alteration of the Hur recordings is reason to keep the recordings and any other government record a secret from the public. So the brief is an important brief. I encourage you to read it. And in fact, I'm going to read a good part of it to you right now. I'm going to take out some of the, because you're not going to believe what the Biden administration argues and what we have to fight in order to get this basic information. I mean, this is a straightforward, I mean, obviously involves the president, but it's under the law, it's a straightforward FOIA request. And in response, the Biden administration's asking the court to engage in a political process to blow up FOIA to protect Joe Biden. So I'm going to read part of it. I won't read all of it. It's available. We'll provide a link to it below. Exemption 5, that's the first exemption. Exemptions, when we reference exemptions, exemptions are reasons, as I call it, that allow the government to withhold information. There are exemptions for privacy and national security, exemptions to protect the release of information that might harm a criminal investigation. And they can cite those exemptions in order to withhold information lawfully. Now, there's always argument over whether the exemption applies and whether it's being properly asserted, but at least it's a legal process, and they just want to blow up that legal process. Exemption 5 generally protects against the disclosure of those records normally privileged in the civil discovery context, including records protected under the executive privilege doctrine. Now, that's the big fight that we're seeing between Congress and Garland. They're asserting executive privilege over these audio files. Executive privilege doesn't apply to that. And this is the introduction. Special Counsel Robert Hur interviewed President Joe Biden about his handling of classified information. The interview was recorded and subsequently transcribed. By the way, they had 2 recordings going on at the same time. We want both of them, by the way. The transcript, which DOJ has officially disclosed, contains both the questions and the answers from the interview. Yet the Justice Department is still withholding the audio recordings that contain the voice of the President of the United States, who has been an elected federal office holder for more than 50 years, speaking the same substantive information contained in the transcript. The law enforcement privilege component of executive privilege not only has never been recognized in a FOIA case, but also only applies to withholding information in an ongoing law enforcement proceeding. Nor does the Justice Department identify the information it seeks to withhold. The recordings don't relate to an ongoing investigation, all of which are fatal to the DOJ's executive privilege claim, as well as the Exemption 7A claim, which is the law enforcement proceedings protection exemption. Finally, President Biden has little, if any, privacy interest in his voice, especially after his long public career, and the fact that his answers are already public. Yet a substantial public interest exists in the audio recordings because the disclosure of them would enable the public to test the veracity of Special Counsel Hur's decision not to recommend criminal charges. And we want the audio recordings released in 14 days. Well, the court should order their release in 14 days after the case is fully briefed. In his final report to Attorney General Merrick Garland, Special Counsel Hur declined to recommend prosecution of Biden for his retention of certain classified records because he concluded in part, "We have also considered that at trial, Mr. Biden would likely present to a jury that, as he did during our interview of him, as a sympathetic, well-meaning elderly man with a poor memory. Based on our direct interactions with and observations of him, he is someone for whom many jurors will want to identify reasonable doubt. It would be difficult to convince a jury that they should convict him, by then a former president well into his 80s, of a serious felony that requires a mental state of willfulness." In response, Biden's White House counsel and his personal lawyer wrote several letters disputing the accuracy of the report. Even Garland says he disagrees with it. He won't prosecute Biden, but he's disagreeing with the reason for not prosecuting him. That's how things work in the Justice Department, by the way. It's Alice in Wonderland. Congress subsequently held a hearing about the special counsel's investigation and his conclusions. When asked about his conclusion that Biden came across as a sympathetic, well-meaning elderly man with a poor memory, the special counsel testified, "Chair, what I can tell you is that my assessment that went into my conclusions that I described in my report were based not solely on the transcripts. It was based on all the evidence, including the audio records." He reiterated, "What I tell you is that the audio recordings were part of the evidence, of course, that I considered in coming to my conclusion." Her provides the best argument there is to get the audios. So as I said, Exemption 5 doesn't apply. This law enforcement privilege, this executive privilege, it doesn't apply. For the government to assert that the law enforcement privilege to apply, that they have to prove that there must be they must show there must be a formal claim of privilege by the head of the department having control over the requested information. Assertion of the privilege must be based on an actual personal consideration by that official. The information for which the privilege is claimed must be specified with an explanation why it properly falls within the scope of the privilege. Focusing on the privilege's third element, DOJ does not identify what information it seeks to withhold. The tape is the recording, but what information on that do they want to withhold? It merely asserts that the audio recordings are exempt from production under the law enforcement privilege. As Attorney General Garland explained in his letter requesting that the President assert executive privilege over the audio recording, the law enforcement component of executive privilege can be asserted to avoid potential damage to proper law enforcement that would be caused by disclosure, including the chilling effect on sources of information. And obviously, an audio recording is a record, not information. So DOJ's failure to identify what information it seeks to withhold is fatal to its assertion. Second, even if the DOJ identified information, the law enforcement privilege only applies to ongoing criminal investigations. This is important. As DOJ admits, the criminal investigation into the possible unauthorized removal and retention of classified documents by President Biden is now closed. Therefore, the law enforcement privilege no longer applies to information, assuming there is any, that the DOJ seeks to withhold. So if this case was like proceeding, and we say we wanted this information, they would say, well, no, we're still running the case. You can't get evidence while we're running the case. But the case is closed. They say there are these other proceedings potentially. They don't name what they are. There's like a future potential hypothetical proceeding that might be impacted, and that's not what the law allows them to do in terms of withholding information to cover potential hypothetical secret proceedings that no one knows about. They're just making up stuff to hide the records. DOJ does not assert, nor could it, that the release of the audio recordings with disclosed unpublished details of allegations against individuals reveal confidential sources, expose investigative techniques or methods, or interfere with the special counsel's decision-making process. It already disclosed a transcript containing the substantive information. So that relates to, well, you know, even if the case is closed, there may be material in the course of the investigation we have to keep secret, like a source or the fact that, you know, we can bug something in this way and not the other way. You can just, I don't need to tell you to come up with scenarios there. But this is just a transcript of Joe's interview. None of that's relevant. Fifth and finally, the mere fact that Congress subpoenaed the audio recordings and the President subsequently claimed executive privilege over them is little relevance here. That process of negotiation and accommodation is a political, not a legal process. FOIA, on the other hand, is a law passed by Congress and signed into law by the President. The court, therefore, can't act or ignore forever DOJ's and now the court's obligations under FOIA, especially since Judicial Watch submitted the FOIA request well before Congress subpoenaed the audio recordings. We asked this stuff before even Congress got to it. Not unusual. It's Judicial Watch. We're always ahead of the game. So they're all this executive privilege fight. That's a political fight with Congress. That's not a reason to withhold information under FOIA. It's a legal process. We have a right to know. You have a right to know about what the government's up to. Because they're getting a political fight with Congress about this. I don't care. I do care about it. We're voters. But it shouldn't impact our right to get the documents independently under federal law. In addition to asserting that the audio recordings fall into the law enforcement component of executive privilege, the Justice Department also argues the audio recordings are protected from disclosure under FOIA Exemption 7A, which allows the government to withhold records or information compiled for law enforcement purposes, but only to the extent the production of such law enforcement records or information could be reasonably expected to interfere with enforcement proceedings. Again, what are the proceedings? Case is over. 15 years ago, an organization called CREW submitted a FOIA request seeking copies or records relating to the interview of Dick Cheney by special counsel Patrick Fitzgerald in a closed investigation into the leak of the name of a covert CIA officer. The specific records at issue were an FBI 302 report summarizing the interview and 2 sets of contemporaneous notes taken by FBI agents during the interview. DOJ failed to disclose the records and CREW sued. During litigation, the Justice Department asserted various claims of exemption, including Exemption 7A. So there was a case almost exactly like this 15 years ago. To support its claim, the Justice Department argued that disclosure of the withheld records could reasonably be expected to interfere with enforcement proceedings because there are likely to be future law enforcement investigations requiring the participation of White House officials, and disclosure of Vice President Cheney's interview could have a chilling effect and deter such officials from voluntarily cooperating with those investigations. Of course, that's just didn't turn out to be true, and the court didn't buy it. The court rejected the claims of the Justice Department. And even though the law hasn't changed in 15 years, DOJ again tries to withhold similar records, relying on the same arguments rejected 15 years ago. As DOJ admits, this Exemption 7A, this law enforcement privilege for ongoing proceedings, essentially, documents and material related to ongoing proceedings, protects law enforcement records that could reasonably be expected to interfere with enforcement proceedings that are, quote, pending or reasonably anticipated. So the case is pending. That's easy to understand. Reasonably anticipated. They're sniffing around someone. They're not sure whether they're going to prosecute. They may. They probably will. And therefore, they're not giving up any law enforcement related records. Makes sense, right? You know, if it doesn't make sense to you under FOIA as to why they withhold stuff, it's you're right to ask the question typically. That's been my experience as head of Judicial Watch with these FOIA cases and the fights we've been having for 30 years at Judicial Watch. It also admits that the D.C. Circuit, which is the appellate court in Washington, D.C., so here, it's the lower court judge. He has to follow the rule set by the D.C. Circuit, the appellate court above him. The government admits, the Biden people admit, that the circuit has held that pending or reasonably anticipated is, quote, temporal in nature. Reliance on Exemption 7 may become outdated when the proceeding at issue comes to a close. If a law enforcement investigation is closed, Exemption 7A most likely no longer applies. Like it did 15 years ago, DOJ also asserts that the release of audio recordings could reasonably be expected to chill cooperation with reasonably anticipated future high-profile enforcement investigations. Possibly, maybe. However, this assertion ignores at least 40 years of binding precedent in which the D.C. Circuit has held Exemption 7A can't justify withholding records unless they relate to a concrete, prospective law enforcement proceeding. Makes sense, right? DOJ does not identify any prospective law enforcement proceeding, let alone a concrete one, to justify its withholding. It rests on a fallacy, merely asserting the obvious. DOJ will conduct high-profile investigations in the future. Such contemplated proceedings are not concrete, prospective, or otherwise reasonably anticipated in any way whatsoever. Now, the judge who handled this case the similar case 15 years ago, Judge Emmett Sullivan, I think he's still on the bench. I mean, his case is kind of the case. Adopting the vague category hypothetical proceedings urged by DOJ would not only be inconsistent with precedent, right? But would also be in direct contravention of the basic policy of FOIA itself. Indeed, the dramatic and far-reaching extension to the current reach of Exemption 7A, that law enforcement, again, exemption, that the Justice Department urges this court to adopt is more properly directed to Congress to consider, and in its discretion to enact it if it sees fit. This court, however, is bound by the law in its current state, which does not sanction such an expansive reading of the statute. And things haven't changed since that decision, and that's the issue right now. They want to rewrite FOIA to protect Joe Biden through judicial fiat. And it gets worse. It gets worse. Of course, you've got the privacy issue, right? Joe Biden needs some privacy. He's in politics for 50 years, 4 years as president of the United States, and we're invading his privacy by having a voice recording of his interviews in a criminal investigation while he's president. It's absurd. It's not like some poor schmo off the street was picked up and questioned and let go, and no one knows who he is, nor should anyone know who he is. He wasn't charged. Who cares? He's the president. A lot of people care. Our lawyers say it a lot better than I do, though, and I'm going to read it to you. DOJ has not identified a single case in which any court has concluded that the audio of an interview in which the transcript has already been released. Remember, the transcript's already been released. Though it's been altered. Further highlighting the need to get the full audio. Again, not a single case in which the court has concluded that the audio of an interview in which the transcript has already been released is protected from disclosure. Because of personal privacy concerns. In the one case in which such an audio recording was withheld, it was withheld not because of privacy concerns, but because the disclosure of the audio would have revealed the identity of a law enforcement source and would have put both the source and the government investigation in jeopardy. It's not the case here. We all know who's being questioned. DOJ's argument is novel. That's a nice way of saying they made it up out of whole cloth. Now, sometimes you can have a novel argument that it's kind of a winner, right? You know? But as our lawyer, Mike Bekesha, who wrote this, says, it makes little sense. It appears DOJ is arguing that President Biden has, quote, a substantial privacy interest in, quote, his pauses, hesitations, mannerisms, intonations, and tone when responding to the special counsel's questions. The D.C. Circuit has unequivocally, however, held that a claim to exemption from disclosures based upon a fear that the taped voice inflections of a person delivering a speech would reveal that person's emotional state would involve such a trivial privacy interest that the claim simply could not rise to the level of a, quote, a clearly unwarranted invasion of personal privacy. Remember, that's the language. Does it sound to you like releasing these audio tapes are clearly unwarranted invasion of Joe Biden's personal privacy? Of course not. Although not explicit, the DOJ seems to suggest that the New York Times should not be controlling, and that's the big case about that I just referenced here. Namely, because the audio recordings were made during a law enforcement proceeding, namely Biden speaking with the special counsel. But audio recordings are not booking photos or mug shots. Photos do not depict substantive information already available to the public. The transcripts already officially disclosed by DOJ, however, reveal the probing questions designed to elicit information about whether a crime was committed and Biden's response. These arguments simply don't hold water. DOJ also goes beyond FOIA. This is a killer. This is just crazy town. Apparently hoping to find an argument that sticks, protective orders by judges presiding over criminal civil cases are not relevant to the FOIA context. So they kind of want the equivalent of a protective order, which sometimes protects privacy and prevents the public disclosure of information in the context of discovery, meaning lawsuits. You can't use everything you get from a lawsuit and put it in the public domain. And a protective order protects the privacy rights of litigants and witnesses. This is FOIA. It's a disclosure statute. Similarly, arguments that the audio recordings cannot be released because of the dangers of modern technology are facile. If government records could not be disclosed because of the concern for manipulation, no record would ever be public under FOIA. Now, remember, the Biden people are saying AI should mean that we don't get the records because AI can manipulate the audio. Well, we don't need to have the document to be released to have AI manipulate Joe's voice in fake audio recordings. It's absurd. And it would be the end of FOIA. If government records could not be disclosed, as I read already, because of the concerns for manipulation, no record would ever be made public under FOIA. No record. Written, audio, video, all subject to media manipulation or computer manipulation, AI manipulation. They're just using AI to make everyone all excited. Even a printed record like a letter, memorandum, or transcript can be altered. In other words, DOJ's, quote, concerns about malicious manipulation of audio files have no limiting principle, meaning there's no line that can be drawn anywhere. They would apply to any record. In addition, it's not entirely clear why the fear of manipulation even falls within the FOIA's personal privacy exemption. Now, the thing about privacy is it's not absolute. You can have a privacy interest, but it's weighed against the public interest. So is there public interest in the release of this material? I mean, come on, I don't have to explain it to you. The Justice Department's pretending there's no public interest in this. Even if President Biden had more than a trivial privacy interest in his voice speaking substantive information that's already been made public, the public interest far outweighs any such privacy interest. Contrary to DOJ's assertion, Judicial Watch seeks access to the audio recording not out of general public curiosity, but because an open question remains about whether Special Counsel Hur's conclusions that Biden should not be prosecuted for his mishandling classified records is supported by the evidence. Releasing the audio recordings would shed light on the special counsel's performance of his duties. Stated another way, the relevant public interest is not to find out what Biden himself was up to, but rather how the special counsel and the Justice Department carried out their respective duties to investigate and prosecute government or criminal conduct. And they say that releasing the audio would provide any little meaningful information to this decision process. But it's contradicted, as we note, by himself. He said, I made this decision in part based on the audio. So of course it's going to be useful to find out what's in the audio. Of course, Congress asked about this as well. And not only that, the attorneys for Joe Biden make it an issue. The White House counsel, the top lawyer in the government, at least in the White House, for Joe Biden, acting seemingly as his personal attorney, it looks like, and Joe Biden's personal attorneys have publicly challenged the special counsel's report, including the assessment that the special counsel based his determination on, the assessment of his poor memory, right? In fact, White House counsel and Biden's personal attorneys have jointly sent at least 3 letters in which they dispute the accuracy of the special counsel's report. There's a big issue here. The release of... Oh, wait, I think I just knocked down my... Did I knock down my... Hold on one second. I'll put it over here. The release of the audio recordings will therefore assist the public in determining whether the president or the special counsel's assessment was most accurate, and whether special counsel's conclusions were supported by the evidence. Biden's disagreement with the special counsel's assessment underscores the public's need for the audio recordings. And Congress has asked for the records. So Congress thinks it's in the public interest. As we summarize, Congress says so too. And of course, generally, whether Hur appropriately pursued justice by recommending to the Attorney General that criminal charges should not be brought against Biden is even more important these days, because another special counsel, with approval by the same Attorney General, is currently prosecuting Trump for engaging in similar actions, allegedly. In addition to Trump being both President Biden's former political opponent and the current Republican nominee, President Trump was the only former president or vice president to be prosecuted for such actions. The public, therefore, has a significant public interest in knowing whether the DOJ had the evidence, but nevertheless pulled its punches when it came to its boss, the current president. And this is the stuff that gets repugnant. I talked about this New York Times case. DOJ asserts the D.C. Circuit's decision, so they're trying to get a lower court to overturn an appellate court decision. That's not the way it works. Supports its personal privacy claims. First, a special counsel's interview of a sitting president about actions he took related to his vice presidency and presidency is not an event of extreme sensitivity. Like the last seconds of the Challenger's crew lives before the shuttle exploded. You heard that right. The Biden Justice Department is saying that the privacy for Biden's interviews with her are warranted because they're just like the privacy that would be expected and was provided for those poor astronauts who died, and their utterances and screams at the last minute. Joe Biden's interview with her is just like releasing the audios of astronauts dying in an explosion? The Justice Department is just beneath contempt in making this argument, in my view. As we say, such a comparison is repugnant. Indeed, indeed. The district court found a substantial privacy interest in the sound of the astronauts' voices because exposure to the voice of a beloved family member immediately prior to that family member's death would cause the challenger's family's pain. And such considerations, we're forced to say, don't apply here, obviously. And plus, the transcripts of the astronauts were released. Every utterance. That isn't the case here because they admitted we forced them to disclose that the transcripts were not accurate. They were altered. So they're telling us to rely on inaccurate transcripts. So there you have it. You can read the full thing. And the reason I took the time to go through it with you here in detail, I mean, it shows you the heavy lifting that Judicial Watch's lawyers have to do to get access to basic information. And that we just don't come on and complain and yell, why are they withholding materials? We have to fight about it in the court and do careful legal analyses to convince a federal court judge to force a powerful government agency, the Justice Department, to give us the document. And it requires a lot of work. And plus, what they're doing here is so destructive potentially to FOIA. Because if the court does what the Justice Department, Biden's Justice Department wants the court to do, or the courts above them to do in the end if they appeal it, as I note, would upend FOIA. As I say in the press release, we hope the court rejects the Biden Justice Department's political request to rewrite FOIA law to hide the Biden tapes. The Biden administration wants to destroy FOIA in order to protect Joe Biden. I mean, that's what's happening right now. So, what's next? Well, CNN filed their brief. I haven't been able to read it. They just filed it before I came to do this video. And then Heritage, our friends at Heritage, are going to file their brief. And we're probably all going to say the same thing, more or less. Lawyers will add words, but the arguments are generally the same. And the nice thing about having three different plaintiffs in this regard is that they all have their separate twist on the argument, so that will be useful for the court to have, and will make our case, I think, more powerful, having two other folks agree with us, including our great friends at Heritage and the lawyers working for the massive media coalition that agrees with Judicial Watch here. And I guarantee you the media isn't going to focus on this, even though they agree with us, and won't expose and report on the ongoing Biden administration effort to destroy FOIA to protect Joe Biden. So I think it's a big deal. I think it's worth talking about. I should have read the whole darn brief. It's so important. And now the government will have some time to respond. We have time to respond again. And then it will be before the court, I think, by the end of July. So hopefully the court moves quickly and we win, but we'll see. We had some more craziness this week on Joe Biden's dog. Now, I disclosed last week how Joe Biden's dog was, or dogs, had bitten upwards of 36 people, including while Joe Biden was supposedly in control of the dog, a poor Secret Service agent was bitten twice in his arm like this. 1, 2 on his arm. Another guy was bitten on his back. So 36 attacks by these dogs. And Judicial Watch alone got the records disclosing all of this and the cover-up related to it. And it was a cover-up. But the Daily Mail, the UK publication, also asked for the records. And other media covered our work here. I mean, Fox did a little story. Let's go to the Fox story about, summarizes some of the work here from Instagram. That was the Instagram post that we posted.
We have new details on Biden's bad dog. The president watched as Commander attacked Secret Service agents.
Evening, Jesse. Judicial Watch giving us an exclusive window into the harrowing circumstances surrounding, you said it, Commander, the president's dog, and his numerous attacks on Secret Service agents, which could, by the way, top 36 such attacks, according to newly released records. What's more, apparently the president himself was present for at least 3 of those attacks. Now, everybody knows Commander has been known to, bite. But there are a lot of examples you may not know about, including this one. Quote, as I started to walk toward him being the president, to see if he needed help, Commander ran through his legs and bit my left arm through the front of my jacket. I pulled my arm away and yelled, no. POTUS yelled, and then blank. Now, the story went on, Jesse, to say that the dog later jumped up and bit him in the left arm again for a second time. His suit coat had not 1, not 2, but 3 holes, 1 all the way through. And that's not it. There are other conversations between Secret Service officials, including this one from September 2023. Heads up and FYI. TMZ just reported a dog bite at the White House. Can we please find a way to get this dog muzzled?
And it gets worse. The Daily Mail asked for records because there were evidently some videos of some of this dog, so at least one video of the dog attack. And here's the Daily Mail story. Secret Service destroyed a video that captured Joe Biden's dog, Commander, chomping down on one of its agents in an attack that forced the White House to shut down tours so blood could be wiped up off the floor. The video purportedly shows Commander running at a high rate of speed and jumping toward the agent in the East Wing's Kennedy Garden, leaving a deep bite on the individual's left arm that reportedly needing stitches. Again, this is disclosed initially by Judicial Watch. The Secret Service's Freedom of Information Act officer wrote to the Daily Mail in a letter Friday that due to Secret Service retention standards, the above-mentioned files have been destroyed, beating the video. So they destroyed evidence. I mean, how else are you going to describe it? And by the way, these records were responsive to Judicial Watch lawsuits. So our lawyers are going to be demanding some answers from the Justice Department and the Secret Service. I mean, Hillary, they hid the emails, and now Joe's hiding videos of his dog attacking Secret Service. So that's the update on the Joe Biden dog scandal that the media pretends isn't a scandal. It's a major scandal. The President of the United States and his wife allowed their family dogs to attack federal law enforcement, Secret Service, and White House staff with impunity. Talk about being above the law. One of the major issues that continue to, I think, damage America is this woke virus, as Elon Musk has described it. This left-wing, radical, communist, Marxist, revolutionary approach to analyzing American history and organizing America. They want to undo America. and destroy the institutions that make America great and are behind our world-first constitutional republic, the most successful in the history of the world. The communists opposed that and want to destroy it. And we've been seeing that up in places even like West Point and the Air Force Academy, the Naval Academy, where woke programming is being used to indoctrinate the rising leadership of our military. And so there was some great concern when it was announced that West Point was going to drop its motto from its mission statement. So the motto of West Point is duty, honor, country, and that was removed just not too long ago from its mission statement. So we sued to find out what the heck's going on up there. So the motto of West Point is duty, honor, country. And on March 12th, 2024, the superintendent of West Point announced the change, referencing the Army's continued commitment to duty, honor, and country, while announcing the new mission statement without explaining why the words themselves were deleted. Now, I think the mission statement has had that, and it gets changed every now and again, so it's not unusual for the mission statement to change. It's changed repeatedly over West Point's history. But to drop the motto concerned many, because it's been in place at least, I think, since 1998, if I recall the documents show. This is what the superintendent said. Duty, honor, country is foundational to the United States Military Academy's culture and will always remain our motto. It defines who we are as an institution and as graduates of West Point. These three hollowed words are the hallmark of the cadet experience and bind the long gray line together across our great country, our great history. Our responsibility to produce leaders to fight and win our nation's wars requires us to assess ourselves regularly. Thus, over the past year and a half, Biden years, working with leaders from across West Point and external stakeholders. Who are they? We reviewed our vision, mission, and strategy to serve this purpose. We believe our mission binds the Academy to the Army in which our cadets will serve. As a result of this assessment, we recommend the following mission statement to our senior Army leadership. And the new mission statement is as such: to build, educate, train, and inspire the Corps of Cadets to be commissioned leaders of character committed to the Army values and ready for a lifetime of service to the Army and nation. Both the Secretary of Army and Army Chief of Staff approved this recommendation. The Secretary is a Biden appointee. My guess is the Army Chief of Staff is one, but I'm not for certain. And as I note, let's be straight. We can't trust anything they're doing up in West Point under the Biden administration. Given the woke virus infecting West Point, deleting the words duty, honor, country from its mission statement has sparked justified concern about what the Army's rising leadership is being taught at the United States Military Academy. And the unlawful stonewalling of the release of records about the issue only makes matters worse. So what are they hiding? If it was no big deal, why can't we get information about this process? Now, Judicial Watch has exposed, working with retired military veterans, concerned Americans in just doing the work on our own, how this woke anti-Americanism, brainwashing is going on in our various military service academies. In July 2023, U.S. Air Force Academy, we exposed they were pushing critical race theory, white privilege, Black Lives Matter. Race and gender instruction was a top priority for the cadets up there, or I should say over there at the Air Force Academy. And of course, the West Point, they were incorporating critical race theory as well at the U.S. Military Academy there, talking about modern-day slavery in the United States. I mean, how does that help us defend the country? Abusing our service personnel. And of course, it's not just at the military academies this is going on. This is all hands on deck. CRT, DEI, woke, you name it. It's anti-American, Marxist claptrap being forced on our rising leaders in the academies and folks already serving. And they wonder why they can't meet recruitment targets. Another big case. You may have seen stories recently about a very strange shooting and death of a citizen that took place in Arkansas. And Judicial Watch has sued for information about it. We sued the ATF, which is a component of the Justice Department, for records regarding the fatal shooting of Little Rock, Arkansas record and executive director of the Clinton National Airport, Brian Manilowski. And basically, we wanted records about the raid on his home that led to his death. He died following an ATF raid in March of 2024, so it was just a few months ago. And the only public records they've made available are heavily redacted copies of the court filing the subpoenas, or the subpoena. And Jim Jordan, the congressman, wants some answers to his questions about the deadly, quote, pre-dawn raid conducted by ATF while executing a search warrant on the home of Manilowski. An affidavit which was unsealed after his death and produced to Judicial Watch already alleged he unlawfully sold guns without a license. His family lawyer and former federal prosecutor Bud Cummings reportedly described Manilowski's alleged gun sales as a hobby and protected by the Second Amendment. In testimony before a subcommittee, a subcommittee of the U.S. House of Representatives, Cummins testified Manilowski never broke any laws selling the way he did, even when a handful of weapons turned up at crime scenes later. So the allegation was he was selling guns he wasn't supposed to be selling, and they were showing up at crime scenes later, kind of like Barack Obama and Eric Holder did with Fast and Furious. Video footage of the raid recently released to the Arkansas Times shows that Manilowski's wife thought that the law enforcement officers raiding their home were intruders. So they're back in their bedroom, they knock, they bang the door, then they bang it open, go in, and according to his wife, they thought they were being, attacked by criminals. He fires his weapon. Allegedly, an ATF agent is injured. They shoot back and kill him. So there are a few questions here. Was the use of force justified? And I don't know the answer to that. Local authorities, I think, have said that it was justified based on their analysis. And assuming that's the case, then what was the reason for their being there in the first place? That force had to be used, or it led to this dangerous situation that resulted in the death of a citizen? Was there a good reason to execute this warrant? What were the plans? Were there enough guys there? Were they well trained? Is there any after-action report about what happened? I mean, these are the sorts of questions we have that we've been getting the hand to the face from the ATF. The Biden ATF's deadly raid on Brian Manilowski's home in what was essentially a licensing dispute, right? screams out for a thorough examination. And slow walking the release of basic information about this raid suggests that the ATF has something to hide. Give us the documents. So I know a lot of you are concerned about this issue, and it's what I love about Judicial Watch. People see things like this happen. They're worried there was some type of government abuse, and they want answers. And oftentimes the government doesn't want to provide those answers, or provides them in a way that raises questions because it's not based on documents. They're just making statements, and you don't know what the real truth is, which is often shown by the actual documents. And this is where Judicial Watch comes in. We sue and try to obtain the records. So a lot going on at Judicial Watch. We're trying to save the country, frankly, by educating the public about what the government's up to, holding the government accountable for misconduct. And we battle the Justice Department. We're battling Biden. We're defending the rule of law, advocating for you, the American people. And if you think this type of work is important, I encourage you to support it. Go to our website to judicialwatch.org and make a donation. And if you're already supporting our work, once again, I thank you for your donations. And I'll ask you again to keep on supporting us because, as you can see, there's a lot more work to be done. Wish you the best, and I'll be here next week, I hope, or next time, with the next weekly update. Thank you. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.